You're listening to a special edition of We Get Work, recorded live from Workplace Horizons 2025 in New York City, Jackson Lewis's annual labor and employment law conference. Over 500 representatives from 260 companies gathered together to share valuable insights and best practices on workplace law issues impacting their business today. Here's your personal invitation to get the insights from the conference delivered directly to you. We'll see you in 2026. Welcome to Workplace Horizons 2025 and live from Workplace Horizons, our podcast series. And thank you for joining me behind the mic today. We have Nikki Jatana, a principal in our Los Angeles office. Nikki, just briefly tell our audience what you do, how you help clients at Jackson Lewis.
So I'm predominantly a litigator, both through trials and arbitrations, but also anything in between. I predominantly handle your typical harassment, discrimination, wrongful termination cases, but a large part of my practice also involves class action work.
Great, thanks. Sitting next to you, Greg Riolo, a principal in our Albany office. Going to ask you the same question, Greg.
Sure, thank you. I am predominantly a litigator, and I also co-chair our Trials and Appeals Practice Group with my partner, Donnie English, who's out of our Baltimore office. And our focus is really in that group is making sure that our attorneys are equipped with the necessary, whether it's trial strategies and trial themes that they have as they go into trial, so we can assist them in any way we can.
And I just spoke to Anna Shields, who was telling me about how certain trials are increasing in number based on what's going on. So let's get into what your presentation was about today, which, not surprisingly, is about arbitration or trial prep. Specifically, what do in-house counsel and HR leaders need to know? So Nikki, tell us just a little bit of brief summary about what that presentation was about at Workplace Horizons.
So what we covered today discussed the role of in-house counsel and the importance of in-house counsel in the trial preparation process or the arbitration preparation process, which, from our perspective, we look at trial and arbitration at the outset when we get the initial complaint. And so we talked about, the communications that in-house counsel needs to have with their business leaders and, all the nuances that go along with that.
So, Greg, what would you say you spent the most time talking about during presentation? What were the issues that you really wanted to share with our attendees here today?
I think what we wanted to share was the involvement that we need from HR and from in-house counsel in terms of their buy-in in the case and their ownership of the case, because we were working with them from the very beginning. They are really our prime contact through the entirety of the case, and we want to make sure that they are comfortable, they have their input into the case. They know what the company is expecting. They know the company's values. They know how the company wants to take approaches to litigation. So we want to make sure that we incorporate that into how we're going to present that case, both throughout discovery, but more importantly at trial.
So Nikki, this year at Workplace Horizons, we're happy to say we have more HR representatives than we ever had before, along with our in-house counsel, registrants, and attendees. What were some of the issues that really resonated with that group of folks, which is now a little bit broader than we've had in the past? Sure.
So I think one of the areas that really resonated had to do with really seeing the outcome of the HR process pre-litigation, right? And so, they really see at, where their efforts to manage, what is going on in the HR process can lead to potentially, if you're headed to trial. And one of the other areas that I think really resonated was the importance of conducting a mock trial because it gives not only the trial attorneys, but the client and the company, the ability to really see how the themes and the issues, could potentially play out at trial.
So we've all been talking about how much has changed since last year, and in fact, how much has changed in the last several months. Greg, what are some of the really significant changes between the last time we got together at Workplace Horizons and this year, and in particular in this space, and how you're helping clients deal with those issues?
I think there's more and more cases are going to trial for a number of reasons, whether demands are too high, whether some stakeholders really want to kind of put a fork in the ground and say, we're not going to do this anymore. We're not going to just settle cases. And I think that resonates with employers and specifically in-house counsel. It also makes it more difficult for the HR and in-house counsel because we've got to make sure that you're taking the right case to trial, because we have some cases where there's very large verdicts, and certainly you don't want to be on the receiving end of those. So I think it's important about getting the buy-in from in-house counsel and taking the right case to trial when you want to kind of say, we're going to make a stand, or we're not going to give in to whatever the demands are. So I think those things are changing. And I think it's kind of indicative of the environment where you'll see a lot more people taking stakes and putting stakes in the ground and saying, we're not going to do this anymore. So I think that that's indicative, and it kind of falls over into the trials.
So you're both going to be really busy, really, is what's going to happen. Nikki, what were some of the other key takeaways you think our audience, our listening audience, and our Workplace Horizons audience need to know?
I think you have to look at every case at the beginning and look at what your trial strategy or your arbitration strategy is going to be. So you're looking at the end, at the beginning, and throughout. I think that's really important. It's not, you do not want to be preparing for trial or arbitration just right before. You want to be building all your themes and what our side of the story is at the outset.
Yeah. So we've talked a lot with other of your colleagues and thought leaders about the importance of being prepared, proactive, and I'm guessing that's a similar theme here. Greg, what else would you say how Jackson Lewis, how you and your colleagues are helping our employers deal with these issues in these critical times?
I think the key for Jackson Lewis, and we always talk in terms of preventive strategies and positive solutions, our old kind of motto that we used to have there. And, now it's we do work and we get work and all of those types of things. I think what it was we want to convince our clients that from the very beginning, we have their interests in mind. We want to know what is going to be the outcome that they want. Some of those we don't want to go to trial. We want to try to resolve cases. Well, you know what? We're going to fight to the end. Both of those are diametrically opposed, but many times they kind of conflate into one another, because many of those you say, well, this is a case maybe you don't want to take that stand because there's bad facts. And what we want to do is work with in-house counsel. They're the ones that have the direct contact with the client. They're the ones that have the confidence of the client from the very outset of the case. And we want to make sure that we're developing that rapport so that if they are convincing their client, you should settle, you should try the case, they have the total buy-in. They know how we're going to approach it. They know the themes in the case. I think the other thing that's important is you have to be flexible, because the very case at the beginning is not necessarily the case that you're going to try. Sometimes it gets better because you find out things that might help you with respect to the plaintiff. Maybe they did something that they weren't aware of or something happened. There's also the opposite, where things tend to get a little bit worse or more problematic. Doesn't mean the case can't be tried, but it just means that we have to be flexible in terms of how we approach that. And I think having in-house counsel or HR people involved from the very beginning is going to get their buy-in, get the confidence of both them and the client to be flexible and change as things approach towards trial.
So the importance of collaboration and a true partnership, which is one of the things that we pride ourselves on here at Jackson Lewis. Nikki, Greg, thank you so much for sharing this time with our We Get Work audience, and enjoy the rest of the conference.
Thank you. Looking forward to it.
Thank you for listening to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate a workforce that is engaged and stable. Please tune into our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on your streaming platform of choice, including Apple Podcasts, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.